Hi, and welcome everyone. We're just getting everyone in from the waiting room, so just give it a moment.
And we're recording. Lansing's. Hey, Jenny. You've checked it. Not especially here. Our Curtis and Bunny. So it's good stuff. Yeah, have you never been in here? I'm trying to like do some cheeks. It's so nice. I just on the way. Yeah.
Okay, I think we may as well get started 5 minutes after the hour. So I wanted to give a big note of thanks to Teresa Donnelly from the Sexual Violence Advisory Group of the Ministry of Attorney General for Ontario. Thank you for the generosity in joining us all from Iqaluit today and giving us of your time to discuss applications in sexual offense cases. So thank you and welcome on behalf of the Lost Society of Nunavut. This presentation is, as you can see, being given live in Iqaluit, and as we also have participants online. So without further ado, I will hand the floor over to Teresa. Thank you again.
Thanks so much. We're just getting set up. So I do have a slide presentation. I'm happy to provide you with a copy when we're finished. If I'm looking a little bit flushed, it's because I just got off a dog sled. So just having a terrific time here in Nunavut. I'm so happy and honored to be here. So I've been a prosecutor with the Ministry of the Attorney General for 31 years. Yes, I know I look too young for that to be possibly true. And for the past 10 years, I've been a prosecutor who's been dedicated to sexual violence prosecutions. With the exception of a small period of time when I went to the Law Society for a couple of years. So what we're going to do, and I'm moving this by way of a mouse, so you got to bear with me. What we're going to do is I'm going to ask if I can get this to work. Sorry. Okay. Bear with me. So we're just going to move to the next slide because maybe that's easier. Right. I'm going to ask you to pick up your phone, join me on menti.com and put in the code. What's the code? Use the code that's at the top of the page. Don't use the one that's on. So the one at the top of the page is 9906-1821. So use the Menti code, go on menti.com. And when you go on menti.com, you should see the slide. Is everybody there? So menti.com, pull it up and enter the code 9906-1821. Is that right? Oh, my glasses on. I can't see that far. Yep. Okay. All right. All right. Mine's not loading, but I hope everyone else is. Okay. And the code is 9906-1821. So hit join and you should be ready to go. Okay. So if we go to the next slide, here's what we're going to talk about. So we're going to talk about applications to get stuff. This is the defense asking the prosecutor for either records that are in possession of the Crown or in the possession of third parties. As JJ calls it, this is the third party records regime. And then we're going to talk about applications to use stuff, and that's use information related to other sexual activity, which relates to 276 of the Criminal Code, or 278.92, and that is the record screening regime or records in the possession of the defense relating to the complainant that the accused wants to use. So those are the three applications in sexual violence cases that are statutory applications we're going to talk about. And then if we go on to the next slide, we'll talk about applications for the Crown. So those provisions don't apply to the Crown, the records screening provisions, and nor does the 276 regime apply to the Crown. What applies to the Crown, if they want to use evidence of other sexual activity, is CBOIR. So we're going to go on to the next slide and talk a little bit about third-party records applications. So to understand why these provisions are in the criminal code, special provisions related to sexual violence prosecutions with respect to the records screening regime and other sexual activity, you really have to understand the law of sexual violence in Canada. And if we go, and Kruk, actually, the recent case out of the Supreme Court of Canada in 2024, from about, I don't know, paragraphs 30 to 45, has an excellent recitation of the law of sexual violence in Canada. And so what you have to understand is that victims or complainants in sexual violence cases have historically been discriminated against by way of the criminal code, but also by way of that information was used against them. So private records were used to attack them, used to undermine them because they sought counseling. And as a result of that, in 1997, the criminal code was amended to provide a regime for the defense to access the records of the complainant. And if we go to the next slide, okay, there, I think we go to the next slide. I don't know, I'm doing it wrong. Okay, good. So these provisions were enacted. Mills holds them to be constitutional. This is referred to as the third-party records regime, which was looked at in JJ in the Supreme Court of Canada in 2022. And it applies to all records, even those in the possession or control of the Crown. So I do want to just stop that. I don't know, can you vote on this?
Yeah.
Can you? Can you vote? Can you let me know if anyone here has been counsel on a third-party records application? We've got a little bit of a problem with this. I'm just gonna, can I just X out of this really quick?
Yeah.
You just stop me presenting?
Yep. There you go.
And can I go over here, manage results? Does that say reset?
Yeah.
Okay, can we present again? All right, now let's try voting. Okay, so we have someone who's being counsel here for the defense. Anyone else? Okay, so let's just talk about these applications then. So, as I said, you have to go back and look at why these provisions exist. So the law, and literally for 4 decades, literally at least since the 1980s, Parliament has been trying to level the playing field in sexual violence cases to make it, and when I mean leveling it, it's so that, as Kruk says, so that they're treated the way in which the prosecutions of other criminal code offenses are prosecuted. And it's really about protecting the rights of women and children. The victims of sexual violence are overwhelmingly women and children, and the offenses are overwhelmingly perpetrated by men against women. That's not to say anyone can't be the perpetrator of sexual violence or the victim of sexual violence, but it has been and remains for decades an overwhelmingly gendered offense. And if you go back and you look at the language of the Supreme Court of Canada and you look at what Parliament has been trying to do for decades, and that is to give meaning to the rights of women and children, given their particular vulnerability to sexual violence. And through the third-party records regime, Parliament is trying to protect complainants' privacy in highly sensitive and personal information. And these provisions, as I've said, are constitutional, and they have been found to appropriately balance respect for the complainant's dignity, privacy, and equality with the fundamental rights of the accused to the presumption of innocence and to a fair trial. So, as I said, they've been found to be constitutionally compliant. If we look then at these, continue to look at that, just think like, and I want you to think, what if your entry to the criminal justice system was, so you felt, if you believed you'd been violated, you went to the police and you reported an offense, any offense, doesn't have to be a sexual offense. You're the victim of offense, some kind of violent crime. And the first thing that the defense counsel wanted to know about you was whether or not you'd been to a counselor. And say you'd been to a counselor because you'd been sexually abused by your father, or you'd had treatment for depression or anxiety. And think how that fact completely disconnected from the fact that you were a victim of an offense, how have the defense having access to those intimate and private details of your life may cause you not to want to participate in the criminal justice system. So you have to think about what the content of these records are. These are personal and private records in which the victim has a reasonable expectation of privacy. And then think about your entry to having someone else know about that, how that would impact on your dignity, your willingness to participate, and how that factors in to the complainant's rights to equality, security, and security of the person and privacy. So I'm going the wrong way. Oops. Sorry.
It's okay. I'll just take over.
Yeah.
This person.
Sorry, I tried.
I use a special mouse.
Okay, so here's a quote from McNeil talking about these provisions, and they are to counter speculative myths, stereotypes, and generalized assumptions about sexual assault victims and the usefulness of these records in sexual assault proceedings. So what is that myth or stereotype? The myth or stereotype is someone who's simply because they've gone to see a psychiatrist or they're under the care of a counselor is less worthy of belief, or they're less reliable as a victim. That's a myth or a stereotype underpinning that. If we could move to the next slide, please. So here it is. This is section 278.1 of the criminal code. It's got a lot in it. But it sets out, there's three really important parts of this provision. One of them is that it enumerates or it lists special categories of documents or information that are records: medical, psychiatric, therapeutic, counseling, education, employment, child welfare, adoption or social services, journals, diaries. So that's one. Second of all, there's a catch-all. It's a record for which there's a reasonable expectation of privacy. And thirdly, that it does not include records made by persons responsible for the investigation of the offense. Those are three key parts of the provision. We can move to the next slide. So, whose records does the third-party records regime protect? Complainants, witnesses, complainants and witnesses, or we're just not sure. Complainants and witnesses. Okay, it's an even tie. Okay, complainants. Okay, go to the next slide. So the answer is, and it's found in the section itself, the answer is it protects all witnesses, not just complainants. So it's different, and Curtis, way to go. And it's different because the admissibility regime is different because it applies just to complainants. And they actually say that in the section itself. If we could move to the next slide. So the first issue you have to determine is it a record? And so what you're looking at, is it an enumerated record? Is it one of those records that listed in 278.1, or is it a record for which there's a reasonable expectation of privacy? If it's not a record, if the third-party record regime doesn't apply, the Crown has an obligation under Stinchcombe to disclose the record. If we could move to the next slide, please. So as I said, starting point, is it enumerated or does it contain personal information? We also want to know what I talked about earlier, was it made by person responsible for the investigation or prosecution? So those are the questions you want to ask yourself. Next slide, please. So this, and then it's easy if it's a medical record, an employment record, a counseling record, a journal, because those are enumerated records. So it helps us understand that it's an included record. Where it's a little bit harder is what if the record is not specifically enumerated or listed in 278.1? What do we do? Well, fortunately, the Supreme Court of Canada in JJ gives us a guideline and tells us what we should be doing. So they say you look at whether or not there's a reasonable expectation of privacy in the material. And if it's not enumerated, you want to look at content and context, and we'll talk about that in the next slide. So think about the content. What information is contained in the document in which the defense seeks production of? Is it information that's intimate or highly personal, that's integral to the complainant's overall physical, psychological, or emotional well-being? Or is it mundane information? Is it information that if it was disseminated would just cause discomfort or embarrassment? And JJ gives us a tip at paragraph 46. It says if the material contains information that would normally be found in a record, it likely is a record. So let's think about that. If the document that the defense seeks, say, is an email in which the victim or complainant is enumerating all her psychiatric treatment, that would be akin to a psychiatric record or akin to a counseling record. It also contains information that's highly personal, and it's akin to an enumerated record. So that would be a record. And that's what we look at in terms of content. So if we go to the next slide, we'll talk about what about context. So with respect to context, we want to look at exactly what that means. Why was the information shared? What was the relationship between the complainant and the person with whom the information was shared? And how was the information shared? So again, we're going back to JJ, Supreme Court of Canada decision in 2022, and we're looking at what's the content and what's the context in which that information is shared. We could move to the next slide. So here's some examples. So explicit discussions or recordings of sexual activity, discussions about mental health, suicide, prior abuse, medical history, involvement in the child welfare system. Most of those listed under yes are akin to enumerated records. If we look to the right, we see mundane information, everyday emotional states, everyday occurrences, general biographical information. So positioning them this way in sort of two columns, you can see that one of them can, the one on the left under yes, contains much more intimate information than the one on the right, and the type of information that it contains. So let's move on. So let's ask you a question and go to our audience. So which of the following communications would be considered records? So A, V asks A for money to purchase a property. B texts about V's medical condition. C, V's political views, or D, talking about the allegations. And if we go to the next slide, we should have a Menti question. So is it A, asking for money? Is it B, medical? Is it all of the above? Not sure. B and D. So medical condition. So we have medical condition, we have not sure, and we have 3 who say it's B and D. And if we go to the next slide, that's right. And here are the cases talking about it. So it'll give you support for the answers, but if you look at the nature of the information in the 2 separate in B and D, it's much more intimate than the mundane, which were A and C. We can move to the next slide. So are sexually explicit recordings related to the offense records? Okay, so interesting, very, very interesting. It's even all across the board. Well, the answer is yes, they are. And if we go back to the definition of what's a record, it's information that is personal. So if we go to the next slide, it's information in which explicit videos or photographs depicting the offense, communications relating to the offense, even though they wouldn't be caught by section 276 of the criminal code because they constitute the subject matter of the offense, they are of an intimate and highly personal nature. So just because, and then I have a tip at the bottom that says, just because the materials depict or relate to the offense are the subject matter of the offense doesn't make them automatically admissible. There's a case there out of the Court of Appeal in Ontario. And what that case was it was obviously a sexual assault case, and there was a photo and video recordings of the sexual activity between the victim and the complainant in the backseat of the car, and the victim and the accused. And the victim didn't know that the recordings were being taken. And the trial judge ruled them inadmissible, and that was upheld by the Court of Appeal. So just because they record what's said to be the offense doesn't make them automatically admissible. Okay, let's go to the next. All right, so what happens if the Crown's in possession of a record? So what if I have a document that's a record? What do I do? So what I have to do is I have to follow the criminal code. And the criminal code says I cannot produce that record to the defense, period. Unless one of two things happens. Either the victim expressly waives compliance with the criminal code provisions, or a court orders me to produce, or a court orders production of the record. So I can't give it over to you. So it can't be, Joanne or Curtis writes me and says, I want this record. I think it's relevant. If it's a record under the criminal code provisions, I cannot produce it unless those preconditions exist. My obligation, though, is to tell you that I have the record so that you can then bring a third-party records application. Next slide. So that just sets out what I've already told you. We can only produce it in two circumstances. Next slide. So if the defense wants access to a record, then they have to bring an application. The provisions and the details of that are set out in the criminal code. So there's a code of procedure that the defense has to follow. I'm not going to read it to you. It's there on the slide, but it's really important that the defense adhere to those provisions. Next slide. So it's a two-stage process. So the first stage is, should the judge even get the record? And what that does is this two-stage process maintains the dignity and privacy and equality rights of the victim or the complainant under stage one. So just because the defense gets the records doesn't mean that the judge automatically looks at them. Because the moment the judge looks at those records, if the judge shouldn't have looked at those records, that impacts on the dignity, the privacy, and in the integrity and the equality rights of the victim or the complainant. So there's a provision that mean that the defense has to meet the threshold for stage one before the judge even looks at them at stage two. And then what the judge is looking at both stages is likely relevance. And what's important is that the criminal code gives the complainant the right to standing and the right to counsel. Next slide, please. And that right to counsel means that that the complainant has an opportunity to instruct counsel. So it's a confidential solicitor-client relationship. she has an opportunity to instruct counsel and to participate in the hearing, which makes sense when you think about this hearing is related to records that are tied to her personal privacy, her dignity, her integrity. And so what this means is that to give meaning to these rights is that we as prosecutors and really as the defense and the judge, because we all have an obligation to ensure that these trials proceed fairly, is we should be engaging counsel for the complainant early in the process and making sure that we're canvassing for dates so that these matters can move along expeditiously with counsel for the complainant. Next slide. So I'm going to leave that for the third-party records application. And this is just really a high-level overview, but let me know if you have any questions. And you don't have to type them in. If you just want to take yourself off mute, feel free to do that. Okay, so I'm going to move on to the next slide because we're halfway through and we still have some things to cover. And I want to leave a little bit of room if I can. Okay, so now we're going to do the other two applications by the defense. So we started with three. We started with third-party records applications, which were the applications to get stuff. And now we're going to talk about the applications to use stuff. So both of these applications say the defense cannot use information unless the court allows them to use this information. And again, like the third-party records regime, the procedures are set out in the criminal code. So if we move to the next slide, again, a two-stage process. And it's different though than the others. So stage one only involves the defense, the Crown, and the judge. It does not involve the complainant's counsel. And if the stage one threshold is met, it moves on to stage two. And at that point, complainant's counsel is engaged. And again, we already know, because we already had a Menti question on this, we know that these records only apply to the complainant. So it's not like the third-party records regime where you're trying to access records in the possession of the Crown or in a third party. These are records the defense already has that relate to the complainant. Next slide. All right, so again, like the criminal code provisions with respect to third-party records regime, the criminal code sets out what the defense has to do with respect to both stages of the application. And you'll note, as we've already discussed, complainant's counsel does not have standing. So in writing, 7 days, detail particulars, talk about relevance. And the criminal code doesn't talk about what the evidentiary basis is for these applications, but DARA in the Supreme Court of Canada does. And it said there has to be an evidentiary basis. It can't be submissions of counsel. And at this stage, DARA says an information and belief affidavit is sufficient. So that is, somebody writes an affidavit that says, I'm informed and do verily believe that the following is true. That type of application of affidavit is acceptable for stage one. If we move to the next slide, please. It is not okay for stage two. And at stage two, a personal affidavit is required. That's DARA. And what you want to think about there is usually the person who's going to have personal information about the other sexual activity of the complainant is the accused. So that likely means a personal affidavit is required at stage two. As we've already discussed, complainant's counsel has standing at stage two. So in Ontario, we have a case in 2022 that says if the defense or if the accused files an affidavit on a 276 application, even if it's unsuccessful, that affidavit can be admissible at trial. The Crown is entitled to cross-examine on it. And if there's any prosecutors who are listening, I encourage you to cross-examine the accused on the affidavit. And the Court of Appeal in 2022 in HP set out the parameters of what that cross-examination can look like. And it's really significant because the affidavit, the cross-examination, is admissible at trial, and it can be used not just to impeach, so not just to challenge the reliability or credibility of the accused, but it can also be used for guilt too. Next slide. So if we are at the stage 2 hearing, the judge will determine whether all or part of the evidence is admissible. The judge will provide reasons, has to tie those reasons to the factors that are listed in the criminal code, including how the information is expected to be relevant to an issue at trial. And the determination of this is a question of law. Next slide, please. So when you think about it as counsel for Crown defense, as the judge, we have to be thinking about moving these applications along, which means pinning down early whether or not these applications are going to be brought, and to ensure that you're talking about these issues at Crown defense pretrials, at judicial pretrials, Crown defense, and the judge. Think about whether or not stage 1 can be done in writing. Crown might want to think about whether or not they concede stage 1. Caution, there's a recent case out of the Ontario Court of Appeal called Reimer that says you should not be blending these stages. And you might want to think too about whether or not you need someone who can manage this, a case management judge, or someone to manage these. There can be a lot of applications, third-party records, 276, application to use the records, or an application by the Crown to use other sexual activity evidence, and different stages. So it can get busy, it can get overwhelming, and you want to keep it organized and keep the process moving. Next slide. So as I said, the record screening regime relates to the complainant, relates to records that are in possession or control of the accused, that the accused intends to adduce. And the bottom line is that this information in the possession of the defense is presumptively inadmissible unless the defense brings an application and the record is ruled admissible. Next slide, please. So we're going to go to a Menti question, and that Menti question is what does adduce mean? And so I'll let you read it on this slide, and then we'll move to the Menti question. Does adduce mean file the record or the document as an exhibit? Does it mean ask questions of a witness about the content of the record? Does it mean testify about the contents of the record? Make submissions about the content of the record? Any one of those or all of the above. If we move to the next slide, we'll get the Menti question. All right. So anyone in the room want to have a conversation about that? Curtis, want to take a shot at it?
I'm going with A.
Okay, Joanne?
I also went with A, but I feel like it's more encompassing than just A. But often when you read a judgment, it just says, oh, this was adduced at trial. And it's the assumption that it's been entered into evidence, and you kind of miss the submissions and the questioning on it.
Yeah, okay, so if we go to the next slide, the answer is E. And that was really clearly laid out in JJ. So we see there, it's given a broad purposive interpretation. If the defense intends on filing the record, referring to the record, so that's paragraph 76 at JJ. It includes reference to the content of the record, that's paragraph 81 of JJ. So it's being given a broad meaning, because if just imagine if defense stands up and holds a record, is reading from a record, and can cross-examine by reading on the record, which contains all the personal information, but doesn't file the hard copy of the record, you're really getting around the section itself, which if we go back to the meaning of the section is all about the dignity, the privacy, and in the integrity of the complainant, and making sure that only evidence that meets the threshold of the criminal code provisions is allowed into evidence. So that's why it's given a broad purposive interpretation, because otherwise it'd be pretty easy to get around the record screening regime. Next. All right, so the test for admissibility, same thing, just like we have for the third-party records regime, it's also set out in the criminal code. So what you want to do is you want to flip to the criminal code, you want to follow the procedures that are set out there, and you want to look at what the admissibility. So if it's 276, we're going to talk about that a little bit more. You'd go to the provisions under 276. If it's records that are in the possession of the defense that the defense wants to adduce relating to the complainant, the evidence has to be relevant to an issue at trial and has to have significant probative value that is not substantially outweighed by the danger of prejudice to the proper administration of justice. So you got to, for the defense, the tip is tie your materials and tie your submissions to what the issue is and be able to articulate why it's significant and it's got significant probative value. I'm going to tell you that my observations of both Crown and defense is that we're not very good at doing that, neither side, of articulating specifically how these things meet the test. And I really encourage you, Crown or prosecutor, to really focus on why it does or why it doesn't, and be specific. It's not okay to say it's relevant, Your Honor, because that just doesn't pass the threshold test. So you want to think through your case and be able to articulate those things. Next slide. So if it's 276, again, the defense has this information. They want to adduce it. You want to be looking at whether these cases are caught by Section 276 of the Criminal Code. And so here's the sort of criteria, and it has to be 276 does not apply if the sexual activity is the subject matter of the charge. That's where we kind of get into a question about whether or not it's part of the subject matter of the charge. Can we move to the next slide? We've had, and so what does this mean, adducing evidence? It's like the adduce question we already talked about in terms of adducing a record. So this includes questioning the complainant, asking another witness about the complainant's other sexual activity. So you couldn't call the complainant's best friend and say, isn't it true she had sex with 3 other men that night? You can't do that. That runs afoul of the 276 provisions because you're adducing other sexual activity. The accused can't get up there and say, well, 2 weeks earlier, the complainant and I did exactly the same sexual act, so therefore she must have consented 2 weeks later. You can't do that. Or you can't file photographs of the complainant, engaging in that activity. So the 276 provisions, the 276 procedures do not apply to the Crown. 276(1) does, which relates to prohibition on twin myth reasoning, but the rest of the provisions don't. Can we move on to the next slide? So one of the issues is, does 276 apply? So 276 sets out specific offenses that are covered. They're listed up there in the top bullet. Child sexual offenses, the sexual assault provisions, and the other provisions, incest, and the other provisions between 160 and 173. But if you go down to the bottom bullet, the human trafficking offenses are not enumerated. So what does that mean? So we have to go down and we have to look at Barton, because what Barton was a case of murder involving the sexual violation of Cindy Gladue. And the Supreme Court of Canada said that even if it's not enumerated, the words in connection with or in proceedings in respect of are broader, which means that the provisions apply to more than just the enumerated offenses. So it could apply. And we've had debate in Ontario probably for about 6 years about whether or not 276 applies to human trafficking offenses. The Court of Appeal, most recently in the case of AM 2024, says it depends. So it's a case-by-case analysis of whether or not it applies. And you'll also see on that slide that it also applies at all stages of the proceeding. So you can't stand up at a bail hearing or at a prelim and ask prohibited questions and think you only have to bring this application at trial. Okay, you're going to move on to the next. And so the 276 tells us that sexual activity includes communication, and it can include evidence done for a sexual purpose, and it doesn't have to include sexual body parts. Next slide. So sexual activity has to, if it forms the subject matter of the charge, it's not covered by section 276. And then we get into, is it part of the subject matter of the charge? And we have two cases, McKnight and Chowdhury, both of them in the Court of Appeal. So I have to update that McKnight site because the McKnight has gone to the Alberta Court of Appeal. And I'll fix it before I give you a hard copy of this. So what you want to look at is whether it's integrally connected, and you want to look at the tests in Chowdhury. And can we move to the next slide? So what happened is in McKnight and Chowdhury, they looked at how connected the sexual activity is to the offense. And it usually happens, say, in a case where there's kissing or sexual activity that precedes what is said to be the non-consensual sexual activity. So you'd go to McKnight and Chowdhury for the analysis of what that test is. And the same is for the third-party records regime. If you're the Crown or the defense, you want to be specifically looking at the test about what the accused has to prove to determine whether or not the evidence is admissible. So you want to, if you're the Crown, you'd look at these things and you'd say they don't make it, they don't meet this. And if you're the defense, you want to address how you are making sure that on a balance of probabilities, you're establishing the test. And again, be specific. It doesn't cut it on either side to make generalized propositions about the complainant, about the evidence, about the sexual activity, about the accused. Be specific and tie it to the circumstances of the case. Next slide. So evidence is never admissible for the twin myths. That is, that a woman consented to sexual activity in the past, she's more likely to have consented. So what's that mean? It means the defense can't say, say the allegation is non-consensual anal penetration. They can't stand up and say, well, 2 weeks earlier, she consented to that same. So that you can't do it for the twin myth, she's more likely to have consented. Or you can't say, well, the fact that she engaged in anal penetration in the past means when she says that somebody, non-consensually touched her breast or penetrated her in some other way, can't really rely on her because the fact that she's had sexual contact in the past means she's not reliable simply because of sexual conduct. Next slide. So this is what I've already told you about, that just because it forms the subject matter of the charge doesn't make it automatically admissible. That's the CI decision. And you really want to look at that case. And even if the record does go in, say it's a videotape of the offense, you should be thinking about how that record goes in. Are there limits on the number of times it can be shown? Do you only show it so that the defense, the Crown, the victim, and the judge can see it? Is there a way to prevent the gallery or the press or other people who are in the audience from seeing it? Should you be sealing the exhibit? You really wanted to be thinking about the dignity and privacy. And for the defense, you might be thinking, oh, I'm not going to be thinking about that. But yeah, you are, because if you're not thinking about that, the judge may say that videotape is far too prejudicial to the victim's dignity and integrity, so I'm not going to let it in. So on the defense, you might want to be saying it's really relevant. We concede that it's really impacts on her privacy and dignity, but here are steps you can take to make sure that those things are looked after. So that sort of weighing or analysis, what the competing rights are. Next slide. So these are essential reading cases that you should know about, Crown or defense, if you're going to be engaging in these types of applications. And Seaboyer, you know, that's the year I was called to the bar, which was a really long time ago. But Seaboyer is as relevant then as it is now. And that's not true of so many other cases where you look and you go back 10 years and you think, oh, is it really relevant law? It's extremely relevant. And you really should know and understand about all of these cases with respect to Section 276. So I'm going to move to the next slide. So what about if I want to lead other sexual activity? What about if I think it's relevant to my case? Say the complainant and the accused had engaged in kissing earlier that night, and then she says something non-consensual happened. What if I want to lead that? Because what if the complainant says, yeah, I kissed him and he was like the worst kisser in the entire world. And I said, I am just never having sex with that guy. And I told him, I want nothing more to do with you. I might say that that's relevant to what subsequently happened, or it's relevant to the accused's knowledge that she didn't consent, or some other way in which it's relevant. If I want to do that and it's not the subject matter of the charge, I can't just lead that evidence. The Crown also has to bring an application. It's not the same application that the defense has to bring, because we're not bound by the procedures in Section 276. So what we want to do is, go back to Seaboyer, that case from 1991 that I told you is just as relevant as today. And we want to look at what the provisions are in Seaboyer, and we want to make sure that we're following those procedures. So that's how we would deal with that. So next slide. So it's really important that the Crown and the complainant figure that out. So now we have 13 minutes. And so what I want to do is I want to do a case study. So I want everyone to take themselves off mute, anyone in the room to talk. And I want you to read the scenario, and then I want to talk about it. So it's a case of consensual sexual activity. Complainant did not know that it had been recorded. And then he sent it to her. He uploaded it to Pornhub. She was very significantly impacted by that. So she brings her counseling records to the police. And she talks about, he had asked if he could video record 2 weeks earlier. So let's go on to the next slide. So here are the questions that I want you to think of. So the judge laid voyeurism for the recording, distribute intimate image for him sending it to her, sexual assault. There's a case out of Ontario that says even though it was consensual, is vitiated by fraud because of the dishonest act. I'm in possession of those counts. I use victim and complainant interchangeably, in case you've noticed that, because Section 2 of the Criminal Code defines what a victim is, and it's a person who includes a person who alleges being sexual or being violated. So they're interchangeable. Okay, so I want to talk about this. What do I do with the counseling records? Victim thinks they're relevant. Victim turns them over to the police. I'm screening the file and I have those records. What can I do with them as a Crown? And if there's anyone who wants to talk about this on the internet, just take yourself off mute. I can't see you. I can only see the screen, but I'm happy to chat. Okay, so that, anyone on the screen? Nope. Okay. Anyone in the room want to talk about what can I do with those records? Anyone?
Disclose them and nothing else, essentially.
Disclose them?
Disclose that you own them or
Okay.
possess them.
Right. So everyone agree? Curtis, agree? All right. Yeah, we've just gone through the third-party records regime. These are counseling records, right? And even though she gave them to me, let's go back to what we talked about with respect to 276. I can only produce them to the defense in two ways. If she expressly waives the requirements of the criminal code provisions, or if a court orders them. Her turning them over to the police is not a waiver of the criminal code provisions. So what I have to do is, what I would probably do in that case is meet with her or refer to complainants counsel so they can sit down and talk about whether or not they are expressly waiving the provisions. I'd want her to talk to her own lawyer about that so they could go through and talk about it. She can get independent legal advice because these are going to be very, very private records. They're counseling records. And it may be that there are portions of them and maybe he talks about what a diagnosis is without going through the whole history of it. So, right, I can't produce them to the defense. I tell the defense that I'm in possession of these records. And if the defense wants them, they either bring an application or the victim could expressly waive compliance with the provisions. And what about the videotape? So the videotape is of the sexual activity. That's the subject matter of the charge. Can the defense introduce the videotape in evidence without an application? You know, I'm going to ask you.
No,
Okay, no, why not?
because they're of such an explicit nature.
Right. So their explicit nature and even though 276 wouldn't apply, to prevent them from being admissible, what the record screening regime would apply because it's intimate and personal details, like we're talking body parts and sexual acts that we're going to be seeing in these. So defense would have to bring an application. Okay, so we talked about what the applicable sections are. And what about this prior conversation about this prior conversation where 2 weeks earlier, the victim had said to the accused, he says, let's record our sex. And she says, like, no way. What would we do about that? Can either of us introduce that? If so, how? How do we do it?
C. Boyer or 276.
Right. So if the Crown wants to introduce that evidence, if I think that's relevant, it goes to the accused knowledge that it was non-consensual, right? Because as an element of the offense, I'll be wanting to prove that because I want to be proving it's a dishonest act. So the Crown might bring an application to say, because it was talking about sex. So I might want to bring an application to adduce that, or for some reason the defense might want to bring it there, that maybe the accused says she said yes in that earlier conversation and somehow that ties into what happened. Maybe he went out and based on that bought a video camera, set it up in the room, had conversations with her, so there may be a way in which the defense says it's relevant. So, but again, they can't just stand up and start asking those questions. So what I just want to tell you is that fact scenario is based on a case out of Ontario called Rockburn. And what Rockburn said is, if the defense surreptitiously videotapes consensual sexual activity, we have a dishonest act, we have deprivation, consent is vitiated by fraud, it's a sexual assault. Okay. So I'm going to flip to the next slide. And we have 6 minutes left. So I know we kind of went over that at a high level, but all I want to do for you is I want you to know that these types of questions in sexual violence cases require applications, and you can't get around those applications. So there's a case in Ontario called Kuzmich from 2020, where at the preliminary inquiry, the defense stood up and asked questions of the complainant about sexual activity with the accused, and without a 276 application. It comes to the trial, they sought to use that evidence at trial to support a 276 application. And the Court of Appeal in Ontario said, no, you can't do that. So you can't do something improperly and then use that to bring a proper 276 application. So there are dangers, you can't do it. Apart from all the ethical obligations that you have with respect to following the law. But the second thing is too, if you're not bringing these applications and thinking through your case, and you should have brought it, and you try to bring it mid-trial, you may be prohibited by the trial judge from bringing those applications if you're sort of engaging in tactical maneuvering and not purposefully not following the criminal code procedures. So it's really important that you understand that these provisions exist, that you follow these provisions, and then that means that what's happening is that there's a fair trial. And what a fair trial is it's a trial that's fair from everyone's perspective, from the complainant, from the accused, and from society and the public, because we all have an interest. Crown, defense, judges, jurors, we all have an interest, society, in the proper functioning of the criminal justice system, and a criminal justice system that's fair and accessible, not one that's inaccessible for people who are victims or complainants of sexual violence. So 4 minutes. Is there anyone who has a question? Anyone in the room? Anyone online? Again, take yourself off mute, or you could put it in the chat, I guess. Any questions by anyone? Curtis, anything?
I have kind of a related, unrelated one. If
Okay.
it comes to a situation where the Crown has these things, but did not disclose it to the defense, that's just Stinchcombe, but.
No, because it's not, because Stinchcombe relates to information that's not clearly irrelevant or otherwise we can't produce. So Stinchcombe doesn't apply to this. What it is it's a violation of the criminal code, right? Because the criminal code says if you have it in your possession, you have to tell them. It's 278.2 subsection 3. So it's a positive requirement on the Crown. So your question's really good, because for the Crown, you have an obligation. So you really want to be thinking every time you have documents in the file, are these covered by section 278.1? If they are, follow your obligations. If they're not, you have obligations to disclose them pursuant to Stinchcombe. And those are really tied to our the core of who we are as prosecutors in terms of our role and our ethical obligations to make sure that we're following the law, but we're also following like our constitutional requirement to make disclosure of information that ought to be disclosed. So it really is important that we're thinking through what's in the Crown brief, content, context, enumerated record, and we're taking the proper steps that we should be taking. All right, any other questions?
I guess at what point, like we always say when we're talking about a file, like that seems mythy, as like you're getting into the 276 problems. At what point though, if you're reviewing a file, do you decide that you're going to bring the applications out of an abundance of caution? That you don't want to get into that situation where it's 2 days into trial and all of a sudden you need to bring the application. Like for you, what's that kind of guiding light between now it's probably time to start them?
I encourage everyone, like if we were having like sort of a how to prepare, and maybe I'll come back and we'll do an online, here's how you prepare your case. I'm not a defense lawyer, but I can tell you from being a trial crown for a really long time. Like, it's just better if you're prepared. And for the defense, sort of leaving things till it's mid-trial. First of all, you could run into problems with bringing it, but you should be preparing your case ahead of time. Your ethical obligation is to your client and is to do the best job for your client. So you should be thinking through ahead of time, sort of not at the last minute, not sort of when you get there, figuring I'll think it out later, and maybe the case isn't going to prove, but think through. And sometimes I said earlier is neither side does a very good job of articulating relevance, and you have to, even as a crown, all the time get over that myth-based thinking. I tell myself all the time, okay, I'm giving advice, don't lay a charge. Am I relying on myth-based thinking to say we don't have a reasonable prospect of conviction? That's our Ontario test. So I always try to self-check myself. So I think that's a good thing for the defense. But think about how it's relevant and how you articulate it. And I really encourage you as defense and as crowns to do the same way. It makes everything a lot easier. Makes your 278 applications, your 276. It makes your submissions in cases a lot better. And we're not going to run afoul of the Court of Appeal either and risk getting an acquittal sent back. So, all right. So what you learn about me is I'm very much a stickler for time. So my clock says it's 1 o'clock, and I try to be very respectful of your time. So to those who joined us online, really pleased that you did. Thank you so much. Thanks for participating in our Menti. And if you have any questions, you can feel free to email me. Thanks so much.